The Limited Liability Partnership Act provides for legal basis to a limited liability partnership which attracts the beneficial features of a company but simultaneously avoids the liabilities of a partnership firm to a considerable extent. This act consists of 81 sections in 14 chapters and 4 schedules. In this short video, we are going to understand and learn about the purpose, key objectives, salient features, important definitions, important provisions, important amendments, and in the end, we will also see important questions. Hello sincere aspirants, I am Mayank and you are watching Legal Bites. You can count on us for all your legal learnings and law exams, be it mock test series, previous year papers, real-time practice or PDFs, study materials and much more. This act commenced on 7th January 2009 and has undergone several changes. Before we start with the purpose or objective of this act, I would like to remind you that you must have a bare act of limited liability partnership and a pen or pencil to mark important provisions. So the purpose. The legislative intent behind the enactment of the act is to provide for an alternative corporate business vehicle which encompasses the benefits of limited liability as in the case of body corporate and flexibility as in the case of partnership firm. The act has series of objectives to fulfill, such as to form a commercially efficient structure of the corporate business, to prove to be a suitable vehicle for small enterprises and for investment by venture capital, and also to enable professional expertise and entrepreneurial initiative to combine, organize and operate in a flexible and innovative manner. So the salient features of the act include perpetual succession, flexibility to devise the LLP agreement as per the choice of the parties, separate legal entity, limited liability of the partners as agreed to in the LLP agreement. Minimum of 2 partners is sufficient and there is one mandate that at least 2 individuals should be designated partners. Then there is maintenance of annual accounts. Here also there is a mandate that the statement of account is filed by registered LLP every year. Further, the compromise arrangement, merger or amalgamation of the LLPs is subject to the provisions of the Act. The Act also provides for winding up of the LLP, voluntary or by tribunal set up under the Companies Act 1956. There are a few notable important definitions which we will be dealing. Please mark in your bare acts as I enumerate. So section 2 clause 1c, appellate tribunal NCLAT, that is NCLAT, is constituted under section 10 FR clause 1 of the Companies Act 1956. Then section 2 clause 1d, body corporate. This is defined to include within the prior definition LLP registered under the Act. Then section 2 clause 1m, foreign limited liability partnership. Section 2 1n, limited liability partnership. Section 2 1o, limited liability partnership agreement. Then there is section 2 1 clause u, subclause u, tribunal. So here NCLT constituted under section 10 FB, clause 1 of the Companies Act 1956. So let us now see some important provisions of the Act. Section 3, limited liability partnership to be a body corporate. Then there is section 6, minimum numbers of partners, that is 2 partners. Then there is section 7, which deals with designated partners. Then there is chapter 10, sections 55 to 58 read with schedules 2, 3 and 4. Conversion to limited liability partnership. Then there is section 59, foreign limited liability partnerships. Then there is chapter 13 deals with section 63 to 65, with the provisions related to winding up and dissolution. Now let us look into the very important aspect, that is important amending act. The Limited Liability Partnership Amendment Act 2021 was a major amendment. Let us look at the key highlights of the Amendment Act. So the key highlights were: the amending act provides for the formation of small LLPs, then the partner contribution has also been talked about, then the turnover has been mentioned, and the power to the central government to form special courts for expeditious disposal of cases pertaining to the LLPs. Also, limitation period of appeals to NCLAT. These things have been dealt with very seriously in the amending act. In respect of the changes in partners of the LLP, change of registered office or filing of statement of account and solvency and annual return, arrangement between an LLP and its creditors or partners, and reconstruction or amalgamation of an LLP. So prior to the amendment, that is pre-amendment, it was an criminalized and as offence. This was criminalized as offence and it was punished with fine. And now post amendment, this has been decriminalized and monetary penalty is only imposed in place. Alright, this is very important. So decriminalization has taken place. Next is section 17 that deals with rectification of name of limited liability partnership. Prior to the amendment, the central government was empowered to direct an LLP to change its name, on failure of which a fine may be imposed. And post amendment, the central government is now empowered to allot a new name to the LLP by itself. So you see the variations. Now section 30 clause 2, unlimited liability in case of fraud. Prior to the amendment, it was punishable up to 2 years, and now post amendment it is punished up to 5 years. And what happens when there is a non-compliance with the order of NCLT? Prior to the amendment, up to 6 months of imprisonment with minimum fine of rupees 50,000 was imposed. Post amendment, this is no more an offence. This is no more an offence post amendment. Alright, so I hope you will find this video very helpful. This will be useful to you for all your exams, or if you are just going to get an insight about the act. I request you to please comment and share your feedback. And yes, don't forget to subscribe to our channel, as your appreciation and support keeps us motivated. Jai Hind, Jai Bharat.